Any good afternoon. My name is Brad Micklin. I'm the managing member of the Micklin Law Group, which is a law firm concentrated in men's and fathers' rights in divorce, custody, and family law issues, with offices in Nutley and Montclair, New Jersey. Today is Friday, got it right this time, Friday, March 29th, 2019. I'm in New Jersey, as I mentioned, so the tip I'm about to give you relates only to New Jersey law. If you're watching this in a different state or on a different date, you have to check to see if it applies. Today is my daily tip where I try to give you a significant issue, but in a very concise way to give you just a practical tip to move along. Today's tip is about what to do once you settle your case in New Jersey divorce and family law cases. And that's going to depend a little bit on where you're settling your case and how you settled your case. So I'm just going to give you some guidelines. First thing to know in New Jersey family law cases is that if you reach a settlement, but you do not put it into writing, you do not have a settlement, meaning it's meaningless unless you write it down and sign it. Now, if you're in court when you settle your case, whether it's in a courtroom or out in the hallway, you don't necessarily need to write it up if you can get into a judge's chambers and put it onto the court record. That can later be transcribed and will actually be probably even better than a writing would be because you'll have every single term put onto it. Once you put it on the record, you still should go and write up a formal settlement agreement or consent order and have it signed and filed with the court because it's easier than dealing with a transcript. The purpose of getting the transcript is really just to preserve the settlement, have everybody acknowledge it and agree to it, and have it recorded in the courtroom. If you are settling your case outside of a courtroom, as I said in the beginning, you want to have it in writing and signed before you leave the settlement conference. Now, often there's going to be additional terms or language that's needed, and you may not be able to get everything done inside of the time that you're sitting in the mediation session. But I would at least recommend that you take the major points and write up a settlement statement of those points that you agree upon. You may want to put into the agreement there are going to be additional terms, but you want to add that those additional terms, whether or not they get agreement in the future, does not change the fact that the parties are agreeing to the paper that you're signing that day. So just in case that's not clear, because it's a very important distinction, write up the material terms that you agreed to. Add in a provision that says we have additional terms that we're going to be writing up, or we're going to be making a larger settlement agreement. But if we don't agree to the additional terms or to the language in the proposed settlement agreement, we still agree to be bound by this writing that we're signing today. That will ensure that you leave with a valid settlement agreement. I hope that helps you, and I hope you do get to settle your cases. It's usually in your best interest to do so. If this information helps you, please give the video a like and share it so that other people get to see it. I'd appreciate it if you want to subscribe, and you'll get notifications when I do come online. I'm planning to be back online Monday, I think at 4 o'clock, as long as my schedule works out that way. And I will also be doing next week on Wednesday at about 4. My plan is a how-to video on how to modify alimony payments after a divorce case. I'm doing for a very good client and a good person that asked me to cover that topic. So look for that for next week. And with that, I'm going to sign off and wish everybody a great weekend.